And we are the Coalition, loud and proud, outrage porn-free, civilly disobedient media broadcasting live on the Worldwide Coalition Radio Network at coalitionradionetwork.com, facebook.com/the Coalition Radio, on the mighty Twitter at Coalition_radio, and of course the mothership, the original website, coalitionradio.us, where we've got 7 years of accumulated stuff, interviews, pictures, conversations, the written word. We've moved it now to coalitionradionetwork.com to reflect sort of the newer, modern, enhanced digital image that we project here, high above the hills in scenic La Prave, Providence, Rhode Island, the naked city, the city of about 300,000 stories. We're going to tell, I think, one of the more interesting ones tonight. Anyone who's ever listened to this show know that we're more than a little bit intrigued by politics. And frankly, while the rise and fall, if you will, almost daily rise and fall, the Trumpanistas is now behind us. We've got the ascension now to heaven of the sainted Joe Biden, who, despite 47 years of an atrocious record as a United States Senator, creating, if among other things, the racist war on drugs, countless state police action / wars, incredible level of infringements upon your civil liberties and your civil rights. Despite all of that, he is the second or third or fourth coming, depending on what your religious tradition is. And the media would have you tell you that the war-torn, riot-torn streets of D.C. will now become peaceful, and honey will flow throughout the land. So, of course, we as a responsible multimedia facility here say to that balderdash. And for the record, we will be the loyal opposition here. We will give him the same honeymoon we gave his predecessor and his predecessor's predecessors, which is to say none whatsoever. So, tonight we've got a very special guest joining us. I had the opportunity to digitally meet him, if you will, as a result of a certain court case that was going on. We had Matt D'Amico on here. It's been a few weeks now. He had the opportunity to talk about, of course, the state's repeated, pernicious, arbitrary attacks on free enterprise, most specifically gyms. Matt gave us sort of a gymnasium / health club course 101 and everything involved in running a business. And then we discussed, quite frankly, the issues surrounding his litigation. At that same time, I had the opportunity to hear his attorney hold forth in the court of law. And it was pretty impressive. You had the sense that, unlike, say, your typical state house proceedings, where it's, Mickey the Dunce versus, and these are my words, not my guess, versus the variety of the knuckleheads that inhabit the Star Wars-like bar scene that surrounds Halitosis Hall, a.k.a. the State House, all credit to Rudy Cheeks, that you actually had an adult in the room and spoke passionately to some of the subcurrents involved in this case. One of which I found the most fascinating was the notion that Ms. Jenner will, in fact, spend ample time with her administration negotiating directly with the restaurant business, but, well, and these are my words, everyone else be damned. Well, the purge, as we call it, we don't call it the pause here, the purge ended, well, we're going to get resolution on the case, but the purge finally ended, and now we're just moderately impinging on people's civil rights, and we're just quietly creating the background for the final stage of the economic collapse of Rhode Island. And I thought it would be great to reach out to him and have a conversation. So we did. And it was at that point in time that I found out he was running to be your next Attorney General. So at that moment, okay, this is someone we have to engage with. So Chas Calenda is joining us tonight. He's a graduate of the University of Miami. I have this straight, both as an undergraduate and law school. He is a practicing attorney focusing on litigation, criminal defense, and business law. He works here in the greater Providence-Warwick area, and he's got quite a story to tell. Not the least of which is, of course, is going to be his run for Attorney General. Chas, welcome to the Coalition for your very first time.
Well, thank you for having me on, Pat.
You're a native Rhode Islander. Give us kind of your little background here. Tell us the Chas Calenda story. You and I have spoken offline. We've already established our bona fides that we have mutual friends, as Rhode Islanders have to do. But give us when the book is written, what will they say about the early Chas Calenda?
I think they said that I was always an ambitious person, somebody that wanted to know more than the rest of the people. I didn't want to just go through life kind of coasting. Born and raised in Rhode Island, grew up in East Greenwich, went to East Greenwich public schools, and I was fortunate enough to get to the University of Miami after 18 years growing up in Rhode Island. Became very interested in politics and law when I was in Miami, especially during the 2000 election, the Bush v. Gore election. That's really kind of decided I really wanted to get to law school and get to know some of these issues. I remember listening to the Supreme Court arguments, the United States Supreme Court arguments as that case was going on, and just being fascinated by the back and forth that was going on between the two parties. And at that point, I decided I wanted to go to law school. Went to the University of Miami School of Law, got back here and was hired as a prosecutor. And I think that when you write the book on me, it's going to be one of someone who has passion for what I do, somebody who is exactly what you see, and somebody who's not going to pull any punches when you ask me some questions.
What prompted you to study the law? When I say the law, of course, I mean the capital LAW.
I honestly think I started, I told you a little bit about just being captivated by the 2000 election, which was the first election that I was able to vote in. And I was listening to the legal arguments that were going on in the United States Supreme Court between the two parties. And I just remember being struck by the fact that they wanted to count different ballots in different ways in different counties, but only the counties that were going to affect the election outcome, or that ones that they were perceived to do that. And it just struck me as something that, anybody with any kind of common sense would say, well, why would you allow something like that? And it just really got me very, very interested in the law. And I kind of geared my curriculum in the University of Miami so I could prepare myself for law school. And I'm glad I did, because it's something I feel all the issues I take on in law, I feel very passionate about. And I think that my body of work speaks for itself in that area.
Now, you worked in the Attorney General's office. Talk about the era that you worked in, who you served under, and what type of cases that you litigated.
Well, I was hired in 2006 under then Attorney General Patrick Lynch. I've worked there for 12 years in the criminal division for my entire time. And within the criminal division, I did everything from juvenile prosecution when I first started to, major felony cases, capital cases at the time I was leaving. And I worked in pretty much every county in the state. I worked originally under Patrick Lynch, who offered me the job. Then I was retained under the Kilmartin administration. And in March of 2018, I gave my notice to leave the office to go work with Inman and Torgy, Greg Inman and Mark Torgy over in Coventry, Rhode Island, where I've been ever since.
Excellent. Now, you've made no secret of the fact that you're in the preliminary stages of running to be Attorney General. So I guess I've got to ask you about a couple of situations and where it might involve client privilege or a discomfort because of confidentialities, ethical issues as an attorney. Feel free to just say that, to tell me that. We have attorneys on this show all the time, a lot of folks who are involved with the ACLU, and it's very difficult to draw ever a clean distinction, if you will, between those areas where confidentiality is required and, in some cases, in some quarters of the state where confidentiality should be ripped apart. So, some of the more controversial. Oh, sorry, go ahead, buddy.
No, you're right. I was just agreeing with you.
Yeah. So you served during a pretty tumultuous time in the Attorney General's office. There was a big distinction between the two administrations. What do you feel? This is a pretty broad question, so feel free to attack it any which way you want. What should be the role of the Attorney Generals in a state like Rhode Island? Whose attorney are they really?
In the state of Rhode Island is one of the very few states where the Attorney General is the criminal prosecutor, the chief statewide criminal prosecutor. And although the office is a partisan election, you run as a Democrat, Republican, Independent, whatever it may be. In a state like Rhode Island, where the Attorney General has primary and in most cases exclusive jurisdiction over criminal law cases, I really do feel that the role should be apolitical, because I saw too many times as I was in that office, whether it was under Kilmartin or under Lynch, and it didn't always necessarily directly come from them. In fact, most of the time it didn't, because they didn't really have a whole lot of day-to-day interaction with the line prosecutors. But I saw it all too often that politics, public perception, what's the media going to say about what we're doing in this case, played too great of a role in deciding what was going to happen with individual cases, as opposed to what the law and facts dictated should happen. And when I was in that office, I have no bones about saying it, I developed a very independent streak. And despite whatever my personal politics are, I developed a very independent streak, and it was one that certainly did not earn me a lot of friends within the administration, the upper administration of that office. But it was one that got me results that my colleagues, both within the office and outside the office, even some opposing counsel, came to respect as being a fair and practical prosecutor.
Mm-hmm.
And I would say that there really was a huge difference, though. You did touch on a point that I did want to bring up. There was a huge difference between the administrations of Lynch and Kilmartin. Patrick Lynch had been in that office as a line prosecutor prior to becoming the Attorney General, and really had the experience he needed to run that office. I can't say the same about Peter Kilmartin, and I don't want to, sit here and bash Peter Kilmartin. He did retain me and give me a job, but it was clear that he did not have the experience to run that office, and he was leaving it in the hands of other people for the most part on the day-to-day basis.
Well, I mean, as fellow Floridians, you clearly have you clearly should have had some sort of camaraderie. I mean, when you went to visit the folks or visit friends down there, or attend an alumni event, you probably could catch a couple cocktails with him, right?
I didn't get to go to Sarasota as often as I wanted to.
There you go. In an effort not to quote put you on the spot per se. I'm not asking for personal judgments, but you're clear there were huge stylistic differences between the two administrations. One of the Attorney General. You look at a Jeff Pine administration, and you look at a Patrick Lynch administration, and regardless of your politics, you got the very real sense that the law was the primary concern, at least as an outsider. During the following administration, it became clear that politics were certainly a significant motivation for what happened, what didn't happen. And, there were initiatives that were pushed. One that I found particularly offensive was the prescription medical database. That was created with, the typical governmental angle of if you're not doing anything wrong, you got nothing to worry about. Nothing to worry about at all. This will be very private. This is for the purpose of science only. And then once Mr. Kilmartin got involved over the anger of groups as disparate as the American Civil Liberties Union as well as the Rhode Island Medical Society, they decided to damn the ethics, and we're going to push a backdoor bill to get warrantless searches of said database, despite the clear privacy issues at stake, as well as, and we argued at the time, the willingness, we as a society fortunately have overcome a number of the prejudices against folks who are suffering from addictions, folks who are challenged by mental health issues. We've finally grown up to the point where, we're going to deal with them rather than shame people. We want people to come out of the quote unquote darkness and seek treatment. And at the time, and I'd love your reflection on this, that seemed to be a serious violation and a real walk back of that notion that we were no longer going to prejudice people. We were no longer going to shame people. What were you around for at that point? And what are your thoughts on that issue and that approach, most importantly, where that Attorney General saw his position in the Attorney General's office, in my humble opinion, as an opportunity to backdoor all sorts of stuff vis-a-vis almost a direct pipeline from the state legislature?
I mean, he came from the state legislature, so I have no doubt that a lot of that was done through, for those reasons. I didn't get much of a chance to sit down day to day with Peter Kilmartin when I worked for him. I did get a few opportunities, and for the most part, we got along just fine. But if you asked him anything about me today, I'm sure he probably wouldn't have a whole lot to say. But I do agree with you that there was a marked change in the way that these issues were approached, and yes, it was very similar to the old, what some areas of law enforcement would tell people. Well, if you haven't done anything wrong, you've got nothing to hide, then give us a statement, come cooperate with us, and we'll put in a good word for you, with the prosecutors when your case goes to trial. That's similar to the prescription medical database issue you were talking about. If you've got nothing to hide, you've got nothing to worry about. Well, we know that's not always the case, because these things are being used and are being accessed for things that they never really should have been accessed for. And I'm somebody who really believes in individual liberties, rights, civil rights. And it's something that, although wasn't involved in it on a day-to-day basis, it's something when you look back on it now, it's just, you can't believe that these things are allowed to happen. And I really originally thought that someone like Peter Noronha, the current Attorney General, right, would kind of look at these things and take a step back from that because of his background. When you look at him on paper, he's squeaky clean. I haven't seen it. I've seen a political ideologue take over that office even worse than I think Kilmartin was, right. And that's to me that's a little scarier, because Noronha has the experience coming from the U.S. Attorney's Office and being an assistant AG in his prior life, and now being the AG. He's got the experience and the knowledge to do some real damage with that approach.
Right, and there was the sense that the Kilmartin administration was just, and again, feel free to comment or not. And I won't judge on that because you're a professional. I'm not. I'm an activist. There was a very real sense that the Kilmartin administration as Attorney General was sort of a mean-spirited, kind of thug-like, dumbed-down attack on some serious issues. You never had the sense, though, that there was this sophistication politically or legally where it could become quote-unquote dangerous. Although some of the damage you did in terms of laws, for example, that would help in opposing the drug war and would help in interdiction and recovery efforts were clearly terrible. I mean, the sunsetting of laws that would protect people who would be willing to respond and call in medical emergencies, as in overdoses, and the allowance both by the Raimondo administration and the current and then Attorney General to allow those to sunset and allow law enforcement to reoccupy that gray area so that they could use every opportunity to take people who were addicted and already marginalized in today's society and really put the screws on them. Now, and go ahead. But before we get into Mr. Noronha, and by the way, I agree with you 100%. He was seen very much as a cavalry, the white knight, if you will, coming to rescue us after the Kilmartin administration. But during the Kilmartin administration, there was really no attempt, if you will, to prosecute white-collar crime. And so the question that comes to everyone's mind, of course, is what we refer to here as 38 Special, a.k.a. 38 Studios. That is still a scar on the state financially and emotionally and philosophically and ethically. How much of that was going on in a different division, admittedly, while you were in the Attorney General's office, and what's your take on what went down legally in terms of 38 Studios?
Well, here's the thing. I was not involved in the presentation to the grand jury of the issues that were involved in 38 Studios. They had what I will describe as very experienced prosecutors looking into that. So in other words, Peter Kilmartin was not in the grand jury room handling that matter. it was they from my understanding, they looked into it from many different angles, but nothing was brought up, no charges were brought. And even if I knew something that had been presented in the grand jury, I wouldn't be allowed to talk about it, simply because the grand jury rules don't allow prosecutors to discuss those issues outside that. And that's one of the things that, I think there was one of the things that was a major issue here, and why the public is so leery about the results of what happened there, was because the law does not allow the attorney general or anybody who was involved in those proceedings to discuss what exactly was brought up. And originally, when Kilmartin was still in office, he had to go to court to defend that secrecy against Governor Raimondo, who was trying to have that released. And ultimately, the attorney general was successful after a ruling from the Superior Court, and I think even the Supreme Court, even after Noronha had taken over the attorney general's office, they had followed up and tried to keep that secret. But I think it was not even a week after that decision came out, you had Peter Noronha turning around and saying, well, even though I won that case, I want to turn around and allow and try to get the laws changed to try to get that information released. And to me, I just don't understand that, because there are very good reasons that, when no charges are brought by a grand jury, that there needs to be some secrecy. Maybe not particularly in this case, all the reasons that would apply, but there are good reasons for that. And those reasons were made and argued by Peter Noronha's administration and Peter Kilmartin's administration. So, unfortunately, I can't offer much insight as to why those charges didn't go anywhere. But we can all sit here and speculate who was involved in what and getting that deal put into place, and who had the ability to dig as far as they could to find out what could be prosecuted and what couldn't be prosecuted.
Right. Well, and educate us, because as I like to say with a smile, I'm not an expert. I simply play one on the radio, like so many Rhode Islanders, right? Too many of us have seen true crimes. Too many of us have seen Law and Order. Too many of us have watched way too much TV and seen way too many movies to understand even remotely what the reality of the battlefield that is our courts. One of the best ways I've ever heard it summed up is that in the halls of justice is usually in the halls. And so you don't, as not being a practicing attorney or an attorney at all, you have no real understanding of what the real rules are. We know how we'd like them to be, but we don't understand it. So a case like that, is a grand jury the only mechanism to bring it through? And if there are other alternatives, and that's my frustration, because by bringing it through the grand jury process, did that effectively put a permanent stifle, if you will, on what the citizens really needed to know?
Yes. And again, I don't know if that was the goal. We can speculate on that all we want, but it did not have to go through the grand jury. The old grand jury is a tool that only must be used in Rhode Island when the attorney general is considering offenses that are punishable by life in prison. And these were none of these charges that could have been considered or could have been brought would have carried a potential sentence of life in prison. So what the attorney general could have done is used any reports by law enforcement, investigations by law enforcement, and signed what's called a criminal information. And that's simply a document that says that has a prosecutor from the attorney general's office, looks at all the reports, looks at the investigation, and determines whether probable cause exists to charge somebody with a crime. And that could have been done. That's not a secret process. And that could have been subject to, at some point, release and disclosure, whereas anything that was presented to a grand jury resulting in a no true bill, or in other words, no indictment came from it, that is now subject to the grand jury secrecy rules. So it's what I call the old prosecutor's trick. They bring it to the grand jury to avoid political accountability and public accountability, so they can just point the finger at the grand jury and say, hey, look, the grand jury didn't want to bring charges, so I can't do anything about it. It was done by Peter Kilmartin, I believe, in that case, in my opinion, and it's been repeated by Peter Noronha shortly after he took office with the Wyatt detention center protests. I think that, it's been used for years. With the prosecutor doesn't want to make a decision that they feel is politically perilous, or that could put them in some sort of media jam or political jam, they just say, all right, just put it into the grand jury and, do what you got to do. And anyone who practices law knows a prosecutor who goes in front of a grand jury basically controls what that grand jury does. If they want to indict somebody, they can 9 times out of 10 indict that person. If they don't want to indict them, they can 9 times out of 10 not indict that person. It's really done behind closed doors to avoid accountability, and that's something that I really think is a stain on the office when it's used inappropriately.
You bring up an excellent segue into the, if you will, the Norona administration. The full disclosure, we've had the folks from Never Again Action on this program a number of times to discuss the events surrounding Wyatt. Post-Wyatt, we've had situations where police officers have been involved in, we'll use a legal term, if you will, pseudo-legal term, questionable post-arrest activities in a variety of marginalized communities. We've recently had a situation where a police officer was involved, depending on who you speak to, a rundown of a citizen or the boxing in of a citizen, which resulted in a serious tragic situation where you've got a young man who is still suffering in a hospital. And the political forces at will on all of those sides will spout cliches and generalizations, and they simply work overtime to avoid any type of prosecutorial action, which may, even if it results in a not guilty plea, will at least bring to light what's happening in the state. Currently, and we publicized it in the coalition just a few days ago, the American Civil Liberties Union is about to engage in litigation and is demanding to understand why Providence police officers refuse to wear their body cameras. And again, this points to a culture that I think Mr. Kilmartin advocated for and advanced, where there is an absence of, if you will, accountability, and I'm being polite here, accountability from law enforcement, from the Attorney General's office. First of all, I'd love your reflection on that as someone who is, again, not just an outside political rabble-rouser, but someone who's immersed in that world. And again, Attorney General Norona was supposed to be the white knight, and he was the kinder, gentler, liberalist East Sider type guy who would only do things for the right things. We'd sing Kumbaya, and all of a sudden, all these stresses in the community would go away. I'll just ask you a bunch of things. What's your thoughts on all of them?
There is a need, obviously, in many areas to hold law enforcement accountable when they step over that line. And I do think that there was a vacuum in that area when under the Kilmartin administration. There was not that consistently used. It's not that to say that it wasn't done. It just wasn't used to the extent that I think it was appropriate. Now, I think we've gone from that somewhat extreme to the opposite extreme. I think now you have the Norona administration, although no charges recently were pressed against the police in this particular situation that you were referring to, some of the ATV issues that are coming up. It's, my dealings with the office, which are extensive. I do a lot of criminal law and criminal defense. My dealings with that office is basically that they have a unit that is simply looking to prosecute police, which I think is just as irresponsible as not prosecuting them when they've done something wrong. There's a happy medium there, and there's a responsibility to do the right thing at the right time when the law and facts call for it, no matter who's on the other side of it. And to be quite honest with you, I don't know why Peter Norona was out speaking to the public about what the results of the investigation were. His office decided there would be no charges. The police department did the investigation. Sure, I'm sure they had the Attorney General's office looking at the legal issues and determining whether or not this is going to be a prosecutable case. And I think if there had been any evidence that they could have used to charge the police, they would have. But really, this should have been the police department issuing their findings, and the AG maybe saying, there just simply wasn't enough to make a charge here. But you look at the difference between the administrations and what their approach is on this issue. It's been completely striking. And to me, there's only one reason for that, is because of politics. Because you had Kilmartin, who himself had a background as a police captain, a police prosecutor, came from the General Assembly, and you have Peter Noronha, who came just kind of, you described him as the white knight coming in, and he's going to change the system. He was going to hold people accountable in a way that wasn't being done before. And I think that our state has been disappointed by both the administrations.
How familiar are you? And you could tell, by the way, folks, when you do an interview like this or a conversation like this, you want to save it for the show. If you have too many conversations offline initially, what very often happens is that we get together online and we stare at each other, and because we've talked about everything. So to a certain degree, I put you on the spot on certain issues because I'm assuming that you know everything, and so I apologize for that advance or that question. But integral to all of this is something called the Providence External Review Authority, and that is essentially I'll call it a citizens board, a citizens review board. Recently, that board voted to fire their head, Jose Batista. He was a full-time executive director. This board was created actually. And folks will be surprised to hear this, this board was given birth after the events surrounding the death of Cornell Young. How many years ago has that been? It seems like an eternity. A young African-American police officer who he got involved in a street incident, very, very nobly, attempting to if you will, be the force that rescued. He got involved in order to mitigate and was shot wrongfully by two Providence police officers. And it was clear in the aftermath of that, it was terrible, terrible, terrible tragedy. A great family. The young family had been involved in law enforcement for generations, and the loss of what I believe now would have been one of the leaders of the Providence law enforcement community. So, I mean, what's your experience with organizations like that in particular? And is that, if you haven't had, is that something you're going to be focusing on in terms of your run for Attorney General?
I'll be honest, I haven't had a whole lot of personal interaction with that particular board. I mean, I'm very well aware of it. It's something that is, something that you're made well aware of when you work in the office of the Attorney General. Just when you're, I had cases when I was working there, when you're obviously looking at police individuals as targets of investigations. So you're getting information from several different sources. That sometimes was one of the sources of information that we would get. To the extent that I'm aware of them, but I do think that community outreach and community accountability is an important issue that the Attorney General needs to be very well involved in. Now, I do think that there is another fine line that the Noronha administration has overstepped. They have, and it's not just overseeing law enforcement, but it's basically the interaction with the community. My understanding is the Noronha administration is out in the community, and mostly of these marginalized communities, giving legal advice to people how to expunge their criminal records. Now, the problem with that is that the Attorney General is the opposing party when somebody files a motion to expunge their record. So you have their prosecutors out on the street giving advice to people whether or not their record is eligible to be expunged, and then they go into court, and there's could be a completely different prosecutor having issues on, having an opinion that's completely different. So to me, you represent the people of the state of Rhode Island, but you shouldn't be giving them legal advice while they're out there on the street. So yes, there needs to be public accountability to from law enforcement, including the Attorney General's office. There needs to be interaction. There needs to be an ability for the Attorney General and law enforcement to show that they are not deaf to the issues that we have in our community when it involves law enforcement. So, that would be a priority issue of mine if I were to be elected to be Attorney General. And it's something that, I do think that has been neglected, not only in Rhode Island, but in many different areas of this country, for the last probably decades, if I had to put a number on it.
Mm-hmm. Currently, police are largely indemnified from any type of damages, if you will, that may come as a result of those few occasions when citizens are actually able to sue law enforcement. Should police have liability insurance? Because ultimately the settlements typically impact the taxpayer. They don't really impact the police officer in those occasions where there's bad behavior.
Yeah, they have what's known as qualified immunity, and I'm sure you've probably had that discussion before. So, I mean, there has to be some sort of immunity, not absolute. Certainly not absolute, and there can't be none, because as anybody who's involved with law enforcement could just bring a claim, and then it kind of would hinder the ability of law enforcement to do their job. But I do think that's an area that needs to have some reform. Because you're right, when situations happen where police make poor decisions or break the law, it's impacting the cities or the states that are paying for their services disproportionately. And I think it needs to be done on a case-by-case basis to look at whether or not, like lawyers, I have to, as a private attorney, I have malpractice insurance if I screw something up. Should we require departments to have insurance against the, for officers who break the law or engage in, otherwise questionable behavior? I think that's a fair question because it should not be a situation where it's black and white. It really needs to be on a case-by-case basis because, as I'm sure you well know, these decisions that are made by law enforcement many times are made in a split second. And right. Whether they're right or wrong, I've never been in that position, so I can't tell you what it's like to be there. I'm sure a lot of people that I know and that probably could tell you a lot better than I can. So to say that there should be no immunity, I think would be a wrong answer. To say that they should have complete immunity would be a wrong answer. But I think there needs to be more access for the public in a situation where there is a clear-cut violation of law or a clear-cut violation of departmental policy to have a little bit more accountability than currently exists.
We're sort of on a roll here. Civil asset forfeiture. Now, full disclosure for folks who haven't listened to the show, I'm a libertarian. So I'm very much at what society would deem right now as one extreme of all of these questions. But how do you feel about civil asset forfeiture?
Civil asset forfeiture is a tool that, if used properly, can be effective. I do believe that in most cases, and I'm not going to, I don't have a single case that I could point out to you in Rhode Island that would point this out, but in many cases throughout the country in prosecutors' offices is being abused. It's because particularly in cases where the allegation is drug trafficking or something of the like, in cases where they don't have the evidence to bring a sustainable criminal charge, they're using a lesser standard of proof to seize assets of people who have been convicted of no crime, who have been convicted of doing nothing wrong, to seize their bank accounts, seize their physical assets on a very low standard of proof. And that has the terrible effect in many cases of undermining the criminal justice system, undermining due process, and that's something that I have a very strong feeling about. Maybe that puts me, in some people's opinion, in the extreme, like you, or like I suspect that you probably have a problem with that. I don't think that's an extreme issue. I think people should have access to due process, and here in Rhode Island, basically, the Attorney General's office has one prosecutor, my understanding, that looks at those types of issues. And if they file that action within 30 days of becoming aware of a situation where civil forfeiture is an option, they do it. It is almost impossible to get those assets back once that has been perfected. Once that action has been perfected. And it was one that was used to the advantage of prosecutors, in my experience, many, many times in the Attorney General's office. One to use as leverage. So they would say, for example, so they would charge a person with possession with intent to distribute a controlled substance, which is a serious felony in Rhode Island, and at the same time seize thousands of dollars in assets at the time of the arrest. Now, a criminal prosecutor looks at that and says, my case is not that great. I'm not sure I'm going to be able to prove it beyond a reasonable doubt, which is the standard in criminal cases. But maybe they make a phone call over to the civil forfeiture prosecutor and say, you know what? I'll make a deal with them to say if they give up their challenge on the civil forfeiture of their assets, maybe I'd cut them a deal on the criminal case. And I guarantee you that's still going on, not only in Rhode Island, but across the country. And it's something that there needs to be a gigantic reform on that, because it undermines people's ability to fight their criminal charges when they may have legitimate issues in their criminal case, which would tend to negate the criminal charges against them.
The next up on the hit list, if you will, cash bail. Maybe you could explain that to folks and the issues behind the bail. I'll call it challenges that face, if you will, marginalized communities.
Well, Rhode Island, in a strictest sense, does not have cash bail. Except for the purposes of restitution. If you owe restitution, the court could set strict cash bail. What they do have is a system of surety bail or personal recognizance. Surety bail, like the Rhode Island bail guidelines, the presumption is you are to be released on your own recognizance unless you have been accused of what they call a serious crime of violence, where you are unlikely to return to the court for your future proceedings. You have a history of recidivism, or there is reason to believe that you will flee the jurisdiction. That's not been the practice in Rhode Island. My understanding, despite the insistence of Attorney General Nerona, my understanding is that surety bail and hold without bail situations are being used routinely in the state of Rhode Island, not just for charges themselves, but for potential bail violators or probation violators. I heard a recent interview with Attorney General Nerona where he says that, particularly during this pandemic situation where they're trying to keep people out of the ACI, that their office is, more often than not advocating for, personal recognizance, release on your own recognizance, so you don't have to give any money to get out of jail or to get out of the court when you're arraigned on these charges. I can tell you that I just had a case where that was not the situation. You have a person on personal recognizance bail for a petty misdemeanor, which is probably the lowest form of criminal charge that you can face in Rhode Island. They pick up another petty misdemeanor, which is nonviolent, both of which are nonviolent offenses. The prosecutor from the Attorney General's office asked that person be held without bail. So they don't even get the opportunity to post cash bail in that situation. The judge in that case, luckily, allowed my client to get bail. It was surety bail, but it was a low amount, so it was reasonable. But it was not because the Attorney General's office was trying to be compassionate or reasonable. It was because the judge recognized the situation did not call for that. So, it's one of the issues I'm running for Attorney General is because what Peter Nerona says and what his office does generally do not connect. He has what I would consider the best of both worlds going on. He says all the right things for the, I hate to even use the word liberal, but the liberal crowd, to make it sound like he's doing the compassionate thing. But when the reality, the practice in the courtrooms is quite the opposite. The prosecutors have no discretion. It's either hold without bail or something as close to it as possible. Cash bail, high surety bail is the norm in these types of situations when people are accused of things that they have not been convicted of, or they're accused of something like a probation violation for pretty much any reason whatsoever. So, this is something where Attorney General Noronha has said, look over here, I'm doing the compassionate thing, but his prosecutors are doing the complete opposite.
The public defender's office is a critical component of, if you will, the legal system in any jurisdiction. Particularly jurisdictions that might be home to folks who are poor, folks who have a variety of financial challenges, the inner city. We've got a very fine tradition in this state of lawyers who do pro bono work for the American Civil Liberties Union. We've got some very fine lawyers who work as public defenders. But overall, I don't think there's any question that area is underfunded and challenged. What's your take, if you will, on public defense here in the state of Rhode Island, and the overall picture, if in fact you're a person who is accused of a serious crime and is without means?
I will say this, that through my entire 15 years of practicing law, the public defender's office has some of the finest criminal defense attorneys that I've ever come across. And I said that when I was a prosecutor. I say that now when I'm in private practice. The problem is the funding and the caseload. And I think that if you asked anybody from the public defender's office about that, they would probably agree with you, that those are the major issues which affect their ability to be the most effective advocates for their clients. It's not to say that they're not effective, because they are. And I've learned that firsthand as a prosecutor and as a private attorney. They're very fine attorneys. And when people ask me about whether they should go with a public defender or hire a private attorney, I always tell them without reserve that they are in very good hands with the public defender's office. The problem is each individual public defender is handling, my understanding, is hundreds of cases at a time.
Right.
And it just does not give them, the ability to do one-on-one work on most of their cases. They have to prioritize. And that's the same for the Attorney General's office as well. They are handling hundreds of cases. Individual prosecutors are handling hundreds of cases. And just logistically, you cannot give each case the type of work that it requires. And when you're a public defender, that is an incredible disservice it's not anyone in particular's fault in that office. It's an incredible disservice to a clientele that does not have the means to go out and spend six figures like Jeffrey Britt did to defend themselves from charges that can be very serious. So it's something that I think is an issue that has to be tackled. I know that the public defender's office has raised these concerns in the past, and I don't know that it's gotten any better. But it's one that I think that needs to be addressed, because simply they lose a lot of good attorneys who are simply overwhelmed by the numbers in that system, because they just don't have the resources to handle the caseloads that they do have.
Right. We had, in the very early years of the show, we had the opportunity to host on a couple of occasions Attorney Robert Mann. And of course, folks will know him from the Craig Price case. Folks, for many years, in the age of Corona, we don't see people as often as possible, but clearly an immense figure, if you will, in public defense, in criminal defense here in the state. Did you ever have a chance to? And by the way, who is a very articulate advocate for the public defender's office, and clearly sees great virtue in that. Did you ever have an opportunity to try a case with him, or be on the other side, or witness him in a courtroom?
Many times. I had I had many cases with Bob, and I know Bob personally, and I think he's a great attorney. And every time I see him, I love to reminisce with him about some of the issues that we used to come across when we were on opposite sides of the aisle. Mm-hmm. But it's, I can't say enough good things about Bob. He has been one of the most incredible advocates for his clients, for public defense, for indigent criminal defense,
Right.
and he does tremendous work for his clients. And I've had the opportunity to try cases against him, to have cases against him, to argue against him, and I actually I've been on the same side of him on other issues. And I actually remember one of my cases, one of the more serious cases I handled in the Attorney General's office. He was opposing counsel, and we ended up working out a resolution which I think benefited everybody, including his client. I think it was a very fair resolution, but he essentially. I certainly don't want to put words in his mouth, but there were compliments coming from me, compliments coming from him as to how that case was handled and which one. It was a homicide, and it was one that was fairly high press, of high level of press. And I think he appreciated the way I handled myself, and I certainly appreciated the way he handled himself in a case that could have been completely contentious from day one, but ended up in a way which I think did justice for all parties involved.
You bring up an important point. One of the things I find fascinating about this state is that our politics, I mean, we don't need no stinking NFL. We got politics here. We don't need no ice hockey. We got politics. I mean, the politics here are so brutal. They're so ethically impaired. And yet when you look at our legal community here, again, we've got this tremendous history of public service, whether it be environmental law, whether it be criminal law, in terms of the public defender's office. And also, again, I mentioned the ACLU, where you've got some amazing attorneys willing to work very difficult cases on behalf of the ACLU, on behalf of our civil rights. And then, quite frankly, they get their expenses. They're doing okay. It's and there are significant expenses in running an attorney's office. People don't understand that. They're just the complexity of the criminal and civil courts system, particularly in the age of the Rona, are challenging. Why do you think that is? Is it just because of the close nature of the community here, the presence of great universities? What's contributed to that?
I think that I can speak particularly for the criminal bar. Both prosecutors and the defense side. It's just a group of people that you work with almost on a daily basis. It's become almost like an extended family. So yeah, you're going to have situations where you're going to be at each other's throats because you're on opposite sides of the issues or whatever it is. Certain issues have to be hashed out. People made mistakes. So you're going to be arguing with each other all the time. But there is a unique closeness, I think, between many members of the prosecution and many members of the defense bar that, the public just doesn't see because they're not there all the time. They're not involved in the courthouse situations that we see on a daily basis. So, people may be surprised to learn that although, as a prosecutor, I may have held different views than someone like Bob Mann. I could respect him as an individual for his work, his body of work that he's done, and for everything that he's accomplished in his career, and know that, we both have jobs to do. And at the end of the day, we're both honest and decent people, knowing that, we've done our job to the best of our ability and can kind of leave that out of our, leave that out of our job, leave that out of our personal lives. This is not a personal issue, and it should never be a personal or political issue when we're doing our jobs, because there's too much at stake here. And, I like to think that I've developed relationships with both sides of the bar that I can take, outside the courtroom, and we can go have a beer together and talk about the situations without, personal hurt or animosity getting in the way of that.
I got to ask you for a little bit of self-reflection here. We've all met attorneys who are very low key and just kind of, take I wouldn't say casual, but a more relaxed environment. And then we all meet these attorneys. Sometimes we're on the wrong side of them, right? Who are just those sharks, those guys who are just going for the throat. All right. Which are you? What's your personal style in litigation?
Yeah, I would consider myself an aggressive attorney. I am not a shark. I would be very clear to point that out. I'm very particular and I'm very blunt with my clients or people who come to see me for advice. Somebody does not have a case and they want me to do something that I just don't see an avenue to get it done in an ethical way. I am very blunt when I tell people that. But I think, as you could tell, when I was arguing the Max Fitness case with the Department of Health last month, I'm not the person that's going to sit back and take punches to the gut without responding. I'm a puncher. I'm a fighter. Sometimes it gets me in trouble. And I'll tell you, during my early days as an attorney, I got whacked by judges and defense attorneys many times for being an aggressive attorney. And it makes you kind of reflect on some of the tactics that you use. I'm certainly not going to sit here and say that I was always right, because I wasn't. And I'm certainly not going to sit here and say that the tactics I used were always right, because they weren't. But I will say that I never, I feel like I always acted in what I felt was a manner that tried to get the right outcome in the situation every time, to do justice for everybody. And I would certainly say that I'm an aggressive attorney who will do everything I possibly can to get the right outcome for my clients and in the situation. And if I'm elected Attorney General, I'm going to do everything I can to ensure justice is done in each case for the right reasons.
Now, take that, because you're clearly entering the world of politics. We had spoken a few weeks ago. We sort of rekindled that today because of a shared, if you will, contempt for a particular situation. By the way, I do want to get to Mr. D'Amico's situation, but since we're talking politics and attitude, there is a state representative who is also I believe he's a criminal defense attorney, who is, and these are my words, I'm very careful to qualify that. I never want to be thought as putting words into your mouth. But from my perspective, he is highly political, being a state representative. That's to be expected. But he wears his Democratic colors, if you will, on his sleeve, and he wears this it's sort of this perverse environment where he's an attorney, and folks, and I understand this, and folks need to understand this, that criminal defense attorneys need to engage in whatever they can ethically to ensure a positive outcome for their client. That's how the system has worked. That's how it's always worked. That's how it's engineered. But what are your thoughts about an attorney who is, at least in halitosis hall, as we refer to it, i.e. the State House, is quite overt about his studied intentional ignorance of folks' fundamental Second Amendment rights, while at the same time bragging, if you will, on his website, it's right there, about his ability to get, quote unquote, criminals off. He doesn't say that way, but you can interpret it. But at the same time, clearly may need a little catch-up. I mean, you guys have continuing ed requirements, right? Maybe he needs a little continuing education on something called due process. And of course, we're talking about the state representative from Warren. What are your thoughts there about that situation and his sort of jihad against Representative Price?
I will tell you that when I saw this representative's tweet today, or the issue of his, his recent statements, talking about how people who merely attended the Capitol protest were, obviously there were crimes that happened at the Capitol in Washington D.C. on the 6th. When he said that people who committed no crimes but who simply showed up should be arrested and jailed. Even if they committed no crimes, I found that to be astounding. I found that to be an absolute disgrace for someone who claims to practice law. I mean, I have never seen a statement like that by an elected official that people took seriously. I mean, this is a person who practices criminal defense, and I am pretty certain that if one of his clients was arrested and jailed for doing something that was not criminal, he would be screaming from the top of the hills that his client was denied due process of law and was being wrongfully incarcerated. But yet, because these people attended a rally or whatever you want to call it, and I don't care what you call it, they were there, and for the most part, people who were there were not committing crimes. There were some, and they should be prosecuted. But the people who were not committing crimes, the fact that he thinks that they should be jailed for simply expressing their opinion on something that was going on, particularly a political opinion, is just completely outrageous. It's antithetical to everything that we believe in as lawyers. And his stand, he has every right to have his opinion on former President Trump. He has every right to have his opinion on what happened at the Capitol. And I certainly defend his right to have that opinion and share that opinion. What I don't defend is his statement that people should be denied due process of law when they did nothing wrong, committed no crime, and they should just simply be jailed for supporting somebody that he clearly does not like.
Right. And I am no supporter of President Trump, now former President Trump, at any level. I ran a political campaign in the state for the presidency for a third-party candidate who was opposed to everything he stood for. But I guess what if there's a way to explain this, and I'm not an attorney, and so I can't. But when folks talk reverently about the law and due process, and it's capital DUE and it's capital PROCESS. When folks talk reverently about that, particularly practicing attorneys, you attorneys have elevated a concept that needs to be reinforced clearly. How important to the entire system of laws, as a nation of laws, for which both sides purportedly support, how important is that concept of due process? I'm Captain Obvious here asking a question, but I don't know that I can really give words to it like a practicing attorney, someone particularly with your experience.
It is the system. Without due process, we are no better than North Korea, Venezuela, or any of those countries who have dictatorships, who put people in jail without trials or use show trials. That is what due process is there to protect against. And if you think people should be jailed because they've committed no crime, but simply because they support some cause that you don't find to be popular or you don't agree with, you have no business practicing law. You have no business holding an elected office in the United States of America. And I say this as someone who knows the representative, who worked with that representative. And I don't have any personal animosity against him because I just don't believe in doing that and having that kind of personal animosity. But I can certainly say with every fiber of my being that if that is his true belief, he needs to give up his law license, because that is just outrageous that he would ignore the basic tenets of due process of law because of his very outspoken political beliefs.
And how critical in a time like this, when the nation's literally at each other's throat, is it for elected officials, whether you be an attorney general, a state representative, or a practicing lawyer, to elevate the conversation and to, rather than take cheap political shots, which, by the way, the other representative to whom he's referring to may have just be equally guilty, and I'm not claiming one side or the other, but how important is it for practicing attorneys, the foundation of our justice system, to elevate the conversation so it doesn't fall into a glorified version of Death Race 2000?
It's vitally important to have a working system of law. You cannot have I don't think you can have a truly functioning, properly functioning legal system when you have attorneys or elected officials who are just simply here to score political points, or just want to take cheap shots at each other to score political points. It undermines our system. It undermines the public's confidence in our system, and it makes it so that people do not want to have anything involved, to be at all involved in the system whatsoever. And it does tremendous damage to our system. And I really do wish, and if anything good can come out of the last few months, I really hope it's that people on both sides can sit back and reflect on the fact that we need an apolitical criminal justice system that is not going to be involved in the political back and forth that we see on a daily basis from both parties. And I do think that both parties are guilty of it right now. And when I saw this particular issue, I just kind of shook my head and said, I can't believe that there are people who actually say these things out loud. it's disappointing to me. I think that we as lawyers need to be above that. As elected officials, we need to be above that, and particularly someone, as who's looking to be the Attorney General of the state of Rhode Island. You need to be above politics, because the power of that office is immense. It is a constitutional office in Rhode Island, meaning that it answers to nobody but the people, because you're elected, not appointed, and you need to be above that, because too many people's lives are in your hands to be playing politics and taking cheap political shots.
And if you look at so many of the after effects of the failed war on drugs, the militarization of today's police forces, the stop and frisk, the organizations like the Jump Out Boys in Providence, and again, these are my words. All of that ultimately is a function of some level of political motivation, where you had in the case of our current president, I'm not a fan. One of the single biggest reasons I'm not a fan is he politicized the war on drugs, gave it steroids from what originally began as part of the Nixon administration, and openly sought to suppress entire communities. And we are paying for that even now. How many years later, since the Crime Act was passed and was advocated for by our current president, the one who has been pictured as the savior, if you will, of this nation, he is directly responsible for that. And a lot of that has to do, going back to the genesis of the Crime Act, with, if I'm tough on crime, people will vote for me. That's the sentiment of this nation. It's not, and it hasn't been, what is right, what is just.
That's exactly right. That's exactly right. And that's where we're missing. That's where we're missing a lot in the criminal justice system. What is right? What is just? Just because the law says this is what you can do doesn't mean that's what you should do. The law is the law, but it's obviously subject to interpretation. And somebody who's the attorney general or a prosecutor in a situation has a great deal of discretion in how they apply that law, how they enforce it, and how it gets done. That's not to say that you should ignore a law that you disagree with, because that's not the role of a prosecutor. That's the role of the legislature. If they don't like the law, the legislature can change the law. But the attorney general in this state and prosecutors in other states have the ability to use the criminal justice system to go for right outcomes, just outcomes. And unfortunately, I think that, we've fallen into a system where politics has been elevated above what's right and just.
Mm-hmm. Wow. I'd like to carry this conversation on in a couple of weeks. I mean, there's so many more things that we can talk about, but it's been a wonderful. Well, I think we started, we were going to be a half hour, and I think we're almost at an hour now. We've covered an amazing amount of turf in that space. Things I'd like to talk to you about in the future. You are running for the Office of Attorney General. You've sort of pre-announced, if you will, and I'm going to give you an opportunity in a minute or two to engage in what we lovingly call on the Coalition Talk Radio shameless self-promotion. We believe that all guests should be given the opportunity to engage in shameless self-promotion. And by the way, for the record, I will invite anyone else running for the Office of Attorney General to join us here on the show and have a similar conversation with accountability. Where were you? What did you do? What were your processes? What were your thoughts? And that goes on everything from 38 Special, as we call it, on through a handful of cases in the last few weeks that continue to challenge us as a community, a state, a body politic. But you are running for Attorney General. And why don't you tell folks, and by the way, something the next time around, just to warn you, I'm a libertarian. I clearly oppose the war on drugs. I clearly support legalization. That's an area that I want to give ample time to. I want to engage in maybe some type of a panel format. And but before you go, I have to ask you, the Club Max, the Jim, Mr. D'Amico, the Club Max resolution. Where does that stand right now, from what you can share with us as his attorney?
Well, the litigation is still pending, but I will tell you this, is that the Department of Health, through its attorneys, have made us an offer of settlement, which does, I'll just characterize it as an offer that I don't think is going to sit well with my client. But be that as it may, we'll see. they've made us an offer of settlement. They're, as you know, they asked for fines because the club had allegedly stayed open during this entire time. So they are looking to get some of that money. Obviously, I have an ethical duty to convey that offer to my client. And I do think that we will have an answer very shortly as to how we are going to approach that. But I do see this as just a much bigger issue than just simply, should gyms be allowed to stay open? Should, there be restrictions in place? There are strong issues of overreach of government power that need to be litigated. And if Mr. D'Amico is in a position that he wants to be the person to do that, I am all for the fact that I would be all for that and all for helping him out to do that. But I suspect that we will know very shortly how this litigation is going to play out.
And the final question, if you will, when you saw that picture of Jeaner, as we say in Rhode Island, at paint night, what was your visceral first thought?
It's just like, she's not technically breaking any rules because she was sitting down at the table drinking a glass of wine when you first saw it, without her mask on. So it's not the fact that she was, breaking rules that got me really upset. What got me upset was just, I don't know if it was a day or two or maybe even a couple days earlier than that. She stood on live TV wagging her finger at us, telling us that we needed to be in a pause, not to go out, not to unnecessarily do anything that was not essential. And here she is caught on film, caught on camera, out at an event that was clearly not essential, setting a poor example as she tells the rest of us that we're all doing the wrong thing, that we're not living up to our end of the bargain. I think that was a very poor example for the governor to set. And I think that was the visceral feeling that I had and many people had upon looking at that. So, did she technically break any of her rules? Probably not. Was she setting a good example? Absolutely not.
It's interesting because I may have had a friend or so involved in the dissemination of said pictures from the get-go, just hypothetically speaking.
Hypothetically.
Yeah, asking for a friend. Isn't that what the kids say now? My thought was this, and folks, there's been a lot of debate back and forth about whether she broke any rules. As part of, and we don't call it the purge here. The pause. We call it the purge because that's the impact it's had on Rhode Island businesses. But there were regulations stipulating to, if you will, rules against providing any level of entertainment whatsoever at a restaurant. And that was towards the end of the second page of the purge rules. The other one, what is it? Don't ever, in the middle of a purge, open the door. If folks in the movies could understand, don't open the door. Those aren't really nice people asking for a handout. Then we would have saved thousands of movies' lives. But on a serious note, the governor, in those rules promulgated by the Office of the Government under executive orders, specifically prohibited entertainment at restaurants. And so our contention was, she would like to picture it as, and, we all saw that little puff piece interview with Tim White from Channel 12, where, oh, Governor, will you ever be able to go out to eat dinner with your husband again? I don't know. I just don't know. Yeah, okay, spare me. But overall, you're right. I mean, it sent a message, and I've gotten to know Mr. D'Amico a little bit. Wonderful gentleman, great business person, and I just can't imagine. Well, no, actually, I heard a little bit of it, but his first thought when he saw that, after all the holy hell, folks like him and Brewed Awakenings and hundreds of restaurants and small businesses around the state have gone through. So we applaud your effort to question, if you will, on a legal basis, the governor's overreach. Because here's the problem. Like I said earlier in the show, I'm not an expert. I just play one on the radio. And like many people, we believe what we think the rules are. I got to believe the government is not enthused about the opportunity to actually explore on a legal basis what the rules are. And, perhaps with someone who's about to become a Supreme Court justice in the state of Rhode Island hearing the case, just saying, as the kids say. Remarkable convenience, huh? What are the odds that the person hearing your case would be, yes, on the grand committee, as they call it? What are the odds, attorney? It's amazing. Here in Rhode Island, the coincidences. Yikes.
Yeah, I don't know. I don't know what the odds would be, but I will say, we did not expect to succeed at that level, at the temporary restraining order level. And I think that the issues that we raised on that initial argument are ones that do need to be explored, and the government has absolutely no intention of wanting to explore, because I think when you have somebody who does a deep dive into these legal issues, there's going to be a lot of questions that just nobody's going to want to answer. Nobody in the government's going to want to answer. And, we'll have to see how this case plays out. But I have a feeling this may be the one, if the Department of Health is going to insist on pushing this case, this may be the one that things get explored.
Yeah. Mr. D'Amico is a man of convictions, as I've come to know.
He certainly is.
And he don't take bleep from no one. Well, listen, attorney, I first of all, Attorney Calenda, thank you so much for joining us. Let's engage in that shameless self-promotion. First of all, if folks are looking for an attorney, tell us about, again, what areas you cover, where you can be found. And I believe you may have some social media up discussing a potential run for the Office of Attorney General.
Yes. For those of you, if those of you looking for an attorney, I am currently in private practice with the law firm of Inman and Torgy, and that's in Coventry, Rhode Island on Nooseneck Hill Road. I can be reached at 401-823-9200. I practice mainly in the areas of criminal defense, juvenile matters, and some general civil litigation, depending on the areas. But it's a wide variety of practice. I have announced my candidacy for the Attorney General's office in 2022. I filed the paperwork with the Board of Elections, and I am currently collecting donations and asking people to help me volunteer to get my word out and the campaign message out for that campaign. You can find my information on my website at CHAS, CHAS, the number 4AG.com. I'm also on Facebook, I'm on Twitter, and I'm on Instagram. Chas Calenda for Rhode Island Attorney General. And I also have just recently opened a YouTube page, a YouTube channel, where I'm going to be posting, hopefully in the near future, some videos, some short clips of videos covering some areas that I think people want to hear about. And my goal, Pat, is to be as accessible as possible, unlike many elected politicians across this country. I think people, unfortunately, when they get elected to a political position, they somehow feel like they're no longer accountable until election time comes. I don't want that to be the case. I want to be as accessible as possible to people who have questions, who want to talk about issues. Whether you agree with me or disagree with me, that's fine. I'd love to have a conversation with you. And I don't expect everyone to agree with me personally or politically. And I think that's something we can all have a great conversation about. So I welcome that. And I certainly would welcome the opportunity to discuss with anybody who would want to discuss it with me, what I truly believe need to be addressed in the Office of the Attorney General, and why I would make the best bet for the Attorney General in 2022.
Excellent. Well, you certainly have a seat here waiting for you to have those conversations, to continue these conversations. It's an open door here to you. Anytime that an issue comes up that you'd like to address, particularly as is reflected in the news cycle, it's as candidacies go, it's a challenge to get above and beyond the white noise, if you will, of Rhode Island politics here in this state. And to what degree that we can get you to be able to disseminate your message and your reflections on some, and some fairly serious issues. As you can tell, this is not exactly lighthearted TV here. We as a show continue to approach and embrace what I call third rail issues, of which there are many in this state, and there are countless, and quite frankly, need to be explored. And by that process, we all grow, and we all, again, reopen Rhode Island government to the people who matter, which is, of course, the citizens of the state of Rhode Island. So I thank you very much for joining us. Attorney Chas Calenda, he is, again, an active participant in criminal and civil law, as well as a candidate for the Attorney General. Chas, I let's keep talking, and let's have you on again soon. And let's talk about, in the next issue, let's set up some sort of panel conversation about the war on drugs and drug legalization. I have a feeling you've got some pretty interesting perspectives on that, given your legal experience.
Absolutely. Thanks for having me on, Pat.
Well, folks, that's it for tonight. As always, we ran a little bit long, but we did the deep dive into the issues that we've always promised you we will. This video will be appearing on YouTube tomorrow and will be shared to the masses in Rhode Island. And I hope you'll reach out to both candidate and attorney Calenda with questions that you have directly or through this show. Folks, we are the Coalition, loud and proud. We're outrage-born free, civilly disobedient media broadcasting live on the worldwide Coalition Radio Network. Facebook.com/The Coalition Radio, on the Mighty Mighty Twitter at Coalition_, and of course, coalitionradio.us. Have a great night. Thank you. What's that?